morning. Our next case is Gardner et al. Versus Richmond County, and we will hear from the appellant.
May it please the Court, Chief Justice Newby and fellow Associate Justices. My name is Brady Herman. I and my co-counsel, T.C. Morphus, represent petitioner appellant Town of Dobbins Heights. If the Court so pleases, I would like to reserve 7 minutes of my time for rebuttal. This case is about what is necessary. What is necessary for a party litigant to adequately show it has an immediate right to appeal the trial court's decision in dismissing them from a lawsuit for lack of standing. Now, this case began, Your Honors, with Dobbins Heights, the City of Hamlet, and 4 property owners bringing a declaratory judgment action challenging the legislative decision by the Richmond County Commissioners to rezone a large property to the heavy industrial zoning district for a proposed biochar production facility. Dobbins Heights was the only plaintiff that was dismissed from the lawsuit at the trial court level for a lack of standing, and when the town appealed that decision, the Court of Appeals, on its own initiative, dismissed the appeal on the ground that the town had failed to show how the trial court's dismissal affected a substantial right to Dobbins Heights. That is the issue before you that was granted review in this case. Now, in the respondent appellee, the county's brief to this court, they also asked this court to review the issue of the town's standing in the interest of justice and judicial efficiency, given that the length of this lawsuit has almost been 4 years. Now, the decision to go and review the issue of the town's standing is completely within this court's discretion. But we agree with the county that this court should go ahead and review and decide upon the issue of the town's standing because we contend that Dobbins Heights has standing in this case. Now, I'll discuss each of those issues brief in turn, all of which is set forth extensively in our briefs to this court. Now, beginning with the substantial right issue, in support of their conclusion, the Court of Appeals stated that the town simply cited to existing precedent, a case that is directly analogous to our case, which is Creek Point Homeowners Association, VHAB. And according to the Court of Appeals, the town's reliance on that case was without analysis, and that an appellant cannot rely on a citation to precedent in order to show a substantial right is affected from. So what the appellate court essentially held was that the town has to go and do more. The town must go and explain why the facts in this case demonstrate that a trial court's order affects a substantial right, and we contend that the Court of Appeals erred in that decision because we didn't just merely cite some general case precedent, but an analogous case, and explain to the court why Dobbins Heights has demonstrated a substantial right will be affected absent immediate review. Now let me go ahead and tell you what happened in the Creek Point case. So in Creek Point, an HOA and one property owner brought suit against one property owner defendant seeking an injunction and damages. The trial court dismissed all claims to the HOA based on lack of standing, leaving the remaining individual plaintiffs' claims for trial. On appeal by the HOA, the Creek Point court concluded that although the appeal was interlocutory, the trial court's dismissal of all claims to the HOA affected a substantial right to the HOA and therefore was immediately appealable. Now, in support of the holding in the Creek Point case, they also went and cited 2 cases, one from this court, specifically recognizing what's called the inconsistent verdicts doctrine. And that is a right to avoid the possibility of inconsistent verdicts of 2 trials on the same issues. That gives rise to a substantial right, giving an appellant an immediate review. Now here in our statement for grounds of appellate review, in our brief to the Court of Appeals, we cited the Creek Point case, we summarized its holding, and we explained why the facts in that case are analogous to our case where Dobbins Heights was dismissed from the complaint for lack of standing, and the other plaintiffs, City of Hamlet and the 4 property owners, remain with their claims.
So let me stop you there. I think I I think you should reframe the third thing that you did, because what you've described is not enough to show that the trial court's order affects a substantial right. What the Court of Appeals precedent says is that, except for a few categories like sovereign immunity, where it's always going to affect a substantial right, it's case by case. So citing Creek Point is helpful to the court because you're saying, here's an example of a past case that found a substantial right. And you might say, and here's their reasoning, because that'll help you. But ultimately, the single most important thing, and the part that you have to do in every case, is to say, here are the specific facts in our case that explain why there's a substantial right that will be affected, and without appellate review, it'll be lost. So what I gather is your theory is it's inconsistent verdicts in this case. So I think what will be helpful is show exactly where in the statement of appellate review you articulated for this case the risk of inconsistent verdicts and why the Court of Appeals was wrong to say you never did that.
Well, so based on those cited cases that we had in our statement for grounds of appellate review, and I'm paraphrasing here, but we went on to go and explain to the court that if on appeal, the town of Dobbins Heights is later on found to have standing after the remaining plaintiffs go to trial on the merits, then that could go and be a risk of inconsistent verdicts on the same factual issues when the town of Dobbins Heights then has its chance to go to trial. Which again was the same risk that caused the Creek Point Court to hold that when one of several plaintiffs is dismissed from the lawsuit, that is an immediately appealable issue.
Yeah, so as I try to understand why the Court of Appeals did what it did in this case, what I'm thinking is because if you look at the complaint that you filed, you have all 6 of the plaintiffs bring, when you get to a first claim, there's no distinction between plaintiffs. It just says plaintiffs bring this claim, the next one, which is different from some of the earlier cases the Court of Appeals has dealt with where they said, okay, there's not a risk of inconsistent verdicts because some plaintiffs are bringing this claim, some are bringing this claim. You can split those off, and in theory, you could have verdicts that can be reconciled. The question is, you didn't put that expressly into the statement of the grounds for appellate review, that the reason why it's inconsistent verdicts is we're all bringing the exact same claim. So if it turns out that your client wins later at the end of the case and says, you're right, you never should have been dismissed for lack of standing, here's your trial, and that jury reaches a different result on the exact same claims. And so, that would be inconsistent verdicts. So my question to you is what the Court of Appeals must have been thinking too nitpicky about what you need to say, or because I think your friend is going to argue that was the missing piece. You never made that point. So what's your response to that?
Sure, Your Honor. Well, it's a little bit twofold because the Creek Point Court, the lower court, the appellate court, really relied on the Doe v. City of Charlotte case. You're very familiar with that case, Justice Deeds. And, in that case, it was specifically held that you have to show why the facts between the claims, the ones that were dismissed and the ones that remain with the trial court. I call those the overlapping claims. You have to show that. You have to show some sort of, common facts to the underlying issue, right? And I only say that because I think that's an important distinction because here we're dealing with multiple plaintiffs all bringing the same claims. Okay, and also go point out with the Creek and the Doe case as well is, all of the plaintiffs still remained in the lawsuit, right? I mean, Dobbins Heights is completely kicked out. I mean, they lose all of their rights absent an immediate appeal. But to get to the heart of your question here, Justice Dietz, is, requiring Dobbins Heights to elaborate on all the particular types of inconsistent verdicts that could arise would be purely hypothetical and skeptical at this point because the parties were only at the pleading stage when the appeal was filed. There were no other facts that we could have argued on the substantial right issue because the only pertinent facts in the record were the complaint, the county's motion to dismiss, and the trial court's order. Thus, we gave all the facts in our statement for grounds of appellate review, analogous to the Creek Point case, which were parties brought same claims, Dobbins Heights dismissed from the lawsuit, as well as one of the other plaintiff's claims, which is not entirely relevant to this issue.
So let me stop you, because so your statement of grounds for appellate review says expressly each of these plaintiffs has the identical claim all brought together in this case. So therefore, if one is dismissed, the other 5 have a trial, and then the final one later has a trial, that could lead to inconsistent verdicts. I mean, I understand that you said a lot more than what the Court of Appeals says Dobbins Heights simply cites Creek Point and asserts the holding in Creek Point requires immediate review without analysis. And that's not accurate, because after you cite Creek Point, you have a long analysis. My question is there maybe just not quite enough on the key question, which is how could there be inconsistent verdicts? So what did you say that gets you there?
Well, I think, again, it goes back to this hypothetical, that I was talking about. And what that is let's say the remaining plaintiffs continue with the case without Dobbins Heights as a party, okay? And it goes to final judgment, whether that's summary judgment or a jury trial. And the plaintiffs lose. So the county's rezoning is upheld. Then Dobbins Heights goes in front of the Court of Appeals, is found to go and have standing, and then they go back and bring either same or similar or different claims. It could be different claims based on additional facts that are obtained through discovery, where a second trial court could find in favor of Dobbins Heights, thus inconsistent verdicts.
Has this court ever adopted the Doe standard?
Do you mean in terms of has Doe been cited besides the?
Have we endorsed that methodology?
I have seen that somewhat common in the inconsistent verdicts analysis, but as I was mentioning to Justice Steach, usually it's dealing with the overlapping claims matter. And the typical scenario for that is one plaintiff against multiple defendants. And let's say a defendant gets kicked out of the lawsuit, whether that's motion to dismiss or summary judgment, then depending on the facts and the underlying claims that are brought, that's where the inconsistencies can arise. And actually, that one particular case is the Jordan B. Burdick Supreme Court case from the 1980s that Creek Point cited. That was a similar procedural posture.
Well, what I'm wondering is, why isn't Burnick v. Jordan controlling?
Well, all of these substantial right analysis, Your Honor, is done on a case-by-case basis, based on the procedural posture and the facts, depending on the challenge ordered appeal from. And that's extremely important, because just one slight procedural posture or one slight claim or different fact can completely change the analysis. And again, that's why we relied on Creek Point, was because it was dead on to our case procedurally. And there's been no other cases that we are aware of that have this same scenario, number one, or have addressed the substantial right and says, no, you don't have a substantial right.
But I guess if we were to follow the Doe reasoning of this court, the point is, you don't need to, the important point is not citing the case like Creek Point. What they're saying is that's much less important than you explaining to the Court of Appeals in that statement of grounds for appellate review precisely what the substantial right is that will be lost. We know that the right to avoid inconsistent verdicts is a substantial right that will be lost. And I think on the record in this case, there's a risk of inconsistent verdicts. What we need to figure out is, was the Court of Appeals correct in saying you didn't articulate it well enough in the statement? So what I keep coming back to is, everything you just described, I think you're correct about that. But show me exactly where in those 2 paragraphs that you have, did you articulate that and the Court of Appeals was wrong to say that you didn't?
Well, again, Your Honor, and I don't have the exact language in front of me, but it's paraphrasing here that if Dobbins Heights were to go and on appeal, is later on found to have standing, and the remaining plaintiffs and their claims go to trial on the merits, then there could be a risk of inconsistent verdicts on the same factual issues, because it's the same claims, when Dobbins Heights then has its turn to go to trial. I mean, that's essentially what we went in and held. And again, pointing to these specific facts, number one, the record is bleak. I mean, we're just at the pleading stage, right? And I'd also say, too, this goes back to, again, the overlapping claims. I mean, the Doe plaintiffs, I mean, they had one categorical sentence, you know, that said some of these claims that are dismissed and some that remain, some of those might go and overlap. And that was it, and then cited to some general case precedent. But this, Your Honor, I mean, this is an analogous case at hand, and citing to a case that's analogous to I mean, that's the most common forms of legal analysis is citing to existing precedent that's analogous to your case. So I don't have a direct answer of what more we needed to go and do, but I will contend that we did enough, and this court should hold that we did enough as well. I want to bring up a very important point that also goes to this overall substantial right analysis that's separate from this inconsistent verdicts doctrine, because that can sort of get lost in the weeds here. But part of the interlocutory or an appealable interlocutory order, what you have to show is affected by its substantial right, and will the appellant be harmed absent immediate review. And here, this court needs to look at the hardship, the grave practical consequences that could occur if a plaintiff, like Dobbins Heights is in this case, is not able to go and have an immediate appeal based on lack of standing. They will have to go and wait 2+ years to have their day in court, when in fact they do have standing. We contend that Dobbins Heights has standing in this case. It's a very harsh consequence, and one that needs to go and be recognized by this court, because as the Creek Point Court, you know, concluded, and I think it was self-evident there, that the mere possibility of multiple trials from one party being dismissed and the other plaintiffs remaining, that creates the possibility of inconsistent verdicts, which, without further justification, affects a substantial right. And we ask you all to go and reverse the Court of Appeals decision and allow Dobbins Heights to have the issue of standing addressed by the Court of Appeals. Or alternatively, moving on to the standing issue. Now, the county, in their brief, suggested to this court that we go ahead and review that issue. And, you know, that's entirely within this court's discretion on whether or not you guys want to go and decide that. But I do, you know, agree with the county, at least on one premise, is, you know, due to the length and delay, you know, justice and judicial efficiency, that's one reason. But number two, more importantly, we firmly contend that Dobbins Heights has standing in this case. So we ask you that you go ahead and review that issue so Dobbins Heights can participate in the lawsuit with the other litigants involved. Now, there are two tests established by this court on standing, okay? The first being, more recently, the Dan Forrest test, the Dan Forrest, committee to elect Dan Forrest the Employees Political Action Committee. That came from 2021. Very lengthy opinion from this court where it went through a whole analysis of what the North Carolina Constitution requires in order to have standing. The court did two things in that case. Number one, they specifically abrogated and repealed what was the former injury in fact standard. So that is no longer required, and the court found that wasn't required under the North Carolina Constitution. And number two, they clarified that standing exists when a party alleges an infringement of a legal right under a valid cause of action by statute. That's the first test. Second test is Taylor v. City of Raleigh, where this court held that where a plaintiff must show, in order to have standing to challenge a legislative decision, they must show a specific personal and legal interest in the subject matter affected by the rezoning. It must be directly and adversely affected thereby. Now I'll briefly discuss both of those standards in turn for why the town of Dobbins Heights has standing here, starting with the Dan Forrest test. Now there are two parts to this test. You must be within the class of persons whom the statute confers a cause of action, which here is well established that municipalities can bring declaratory judgment actions, and the Declaratory Judgment Act is the appropriate cause of action to challenge legislative decisions. And number two, Dobbins Heights must have alleged an infringement of a legal right. even when there is no factual injury involved. Now, a year after Dan Forest, this court also addressed an issue of standing in a declaratory judgment action. It didn't have to go and deal with a challenge to a rezoning, but that was United Daughters of the Confederacy v. City of Winston-Salem. And what the court explained about the Dan Forest test, since it was so new, is that you can't just go and file a declaratory judgment act and that confers standing under Dan Forest. You have to do a little bit more. You have to show some sort of harm. So here, the town, in their complaint, made extensive allegations. It's all set forth in our complaint as well as our brief of why the town has standing under the Dan Forest test, the infringement of the legal right. And namely, that is the severe negative impact that a biochar production facility, which is the proposed use for the rezoning at issue, what that will have on the town's water supply. Less than 2,500 feet from the property site is a body of water called Marks Creek. That is owned by the city of Hamlet, but both the city and Dobbins Heights use for its public water supply that serves approximately 10,000 citizens amongst them. Now, as alleged in the complaint, a biochar production facility cooks untreated creosote railroad ties using a pyrolysis process that turns it into charcoal. Now, creosote is a well-known carcinogen, and the burning of carcinogens are very harmful for the environment as well as humans. And so, in the complaint, Dobbins Heights alleged that the toxins and pollutants that stem from this biochar production facility or any other proposed industrial use will not only increase the air pollution, but could likely go and contaminate the ground and surface waters that feed into Marks Creek, significantly impacting the town's water supply. All as a result could negatively and significantly impact the town in Dobbins Heights drinking water and the health, safety, and welfare of the town of Dobbins Heights citizens.
Counsel, is this issue standing? Is that something that you presented in your petition for discretionary review?
I did not bring it up, Your Honor, and here's why.
Well, I mean, if the question is you, or the issue is you didn't bring it up in your petition for discretionary review, have we granted review on the issue of standing?
You have not, Your Honor. It's just
it seems to me that the issue before us is what is in the petition for discretionary review.
Well, fair enough, Your Honor. And you know, I do think this court has a discretion to go and review the standing issue from the case that my colleague opposing counsel cited. But you are correct that, you know, I did not raise that in the petition. It was raised by my co-counsel, and then we obviously responded with our reply brief.
I just have a practical, sorry.
Go ahead.
Just so I understand the status of the case, the trial court is not moving forward with the case as to the other 5 plaintiffs. After you appealed, did the court believe it didn't have any jurisdiction over the remainder of the case?
Well, that's an interesting question, Your Honor. What I'm going to go and say will be facts
I understand. I'm asking you something out of the record.
So the case was stayed from what I would say me and my colleague contended that it should be stayed. And we actually had a motion for a stay back in, I think, early April in front of it happened to be a Scotland County judge. They denied our motion. So we are currently pursuing discovery.
Thank you.
And with that, I will go ahead and reserve the remainder of my time. Thank you.
Good morning, Mr. Chief Justice and Associate Justices. May it please the court, I am Hal Kitchen. My colleague Dylan Bensinger and I represent the appellee, Richmond County. In this case, the town has failed to substantiate the jurisdiction of our appellate courts over this appeal. This is true not only because the town failed to sufficiently articulate its substantial right argument before the Court of Appeals, but more importantly because the town simply does not have a substantial right that would be lost absent an immediate review of the trial court's interlocutory order.
Let me stop you because I want to ask you the same thing I asked your friend about the first part of your argument. So the Court of Appeals said, Dobbins Heights simply cites Creek Point and asserts the holding in Creek Point requires immediate review of Dobbins Heights appeal without analysis. The statement of grounds for appellate review does have a full paragraph discussing Creek Point. Then it says, akin to Creek Point, here the trial court concluded that Dobbins Heights lacks standing, but that all other plaintiffs have standing. Were this court to conclude that Dobbins Heights does have a substantial right affected and dismiss this appeal, there would be the possibility of two trials, one for the remaining plaintiffs and one for Dobbins Heights, if the court were to find that it has standing through the subsequent appeal. Two trials on the same issue would raise the possibility of inconsistent verdicts, and per this court's holding in Creek Point, that duplicative litigation would work significant injury and prejudice. I mean, what more could you possibly say? This seems completely different from Doe, where there was nothing. So I can't figure out what the Court of Appeals was getting at when saying they had no analysis. That's more analysis, I think, than I've ever seen in a statement of grounds for appellate review on this question. So what's going on here?
Well, Your Honor, first, I agree that there was no analysis in Doe. I agree that you can't say that there was zero analysis here. What I would say is that the analysis was still insufficient in the respect that it is not enough, in our view, to simply say that there could be verdicts that could be inconsistent with one another. As the court knows, our jurisprudence says that those two potentially inconsistent verdicts need to be shown to be potentially irreconcilable with one another. In fact, there are cases where our appellate courts, in the Green versus Duke Power case is an example of this, where our appellate courts have recognized that a litigant may have to undergo two different trials and there may be two different verdicts, but unless that litigant can show that they are that could be irreconcilably inconsistent with each other, they haven't shown enough under the inconsistent verdict.
So let me ask you, because in this case, there's a complaint. There's 6 plaintiffs, I believe it's 6, and they're all bringing the same claim. So it'll say first cause of action. There aren't some claims that are for these plaintiffs and some for these plaintiffs. So it's all the plaintiffs bring the exact same claim. So suppose what happened in the statement of grounds for appellate review I just read to you is in fact what happens. So the 5 remaining plaintiffs go to trial and they lose on the facts. And then this thing goes all the way through the appellate courts after final judgment, and ultimately the appellate courts say Dobbins Heights had standing. So Dobbins Heights goes back down and says, well, I'm not bound by that, those factual findings by that jury. I was involved in the case. So there's a new trial, and in that trial, a jury deliberates on the exact same factual questions, and Dobbins Heights wins. Aren't those inconsistent verdicts? I mean, how would you put the, and from your perspective, your client say, well, what's going on here? Because I have one judgment that says we can go forward with this rezoning, and then I have another judgment that tells me I can't. What do I do? So what, isn't that inconsistent verdicts as our doctrine describes it?
Those would be, in your hypothetical, Justice Deeds, inconsistent verdicts. However, in order to answer your question more fully, I'm going to back up to sort of what is the touchstone for showing that you have a right as an appellant to an immediate appeal of an interlocutory order. And that is, among other things, you have to show that without an immediate appeal, you have a substantial right that will be lost. In other words, you as the appellant have to show that without an immediate appeal of this interlocutory order, I am going to be harmed, and here is how I'm going to describe how I'm going to be harmed. So let me get back to the hypothetical.
Right, so you're going to switch my hypothetical. I assume this seems to be your best argument. If the 5 plaintiffs win, so instead of it being they lose and then Dobbins Heights wins, if the 5 plaintiffs win, then Dobbins Heights gets what it wants, so it suffered no prejudice. It just doesn't want the zoning to go forward. And if it later went and said, well, I'm going to keep going anyway, even though there's no point, we already have one judgment, and lost, who cares? Because you have a judgment saying you can't move forward with the rezoning. Is that the argument.
Well, that's half of my argument. And I will say in that.
Does our doctrine really allow us to sort of slice it that thin? I mean, the verdicts would be inconsistent. And I'm not, do you really have to then show that it would, you have this risk that the precise harm that you imagined must come to pass, and not just the idea that you end up with two courts on the exact same factual questions coming to different outcomes?
Let me try to answer your question, Justice Deeds, by maybe coming at it from a slightly different angle. First, I would say in the hypothetical, the sort of best argument hypothetical you've raised, where the existing trial court plaintiffs go forward and win at trial, then given that very capable attorneys represent the town of Dobbins Heights, I would fully expect Dobbins Heights' claim to go away. That would be what we would expect there. And so in that event, they would not be harmed. Let's look at the original hypothetical, though, and this is the one that Dobbins Heights, in this court, when forced to use more words because of the outcome at the Court of Appeals, where they present this hypothetical on page 9 and then again on page 11 of their brief, and they say the trial court plaintiffs currently in the trial court go forward and lose. Then we appeal. We get the standing decision of the trial court reversed. We get sent back to the trial court, and once we arrive back in the trial court, we go forward with our claim against the county, and we prevail. Those would be two inconsistent verdicts. However, that is not a scenario which we contend the town can claim is a scenario that is harmful to the town. And that's the key, because as the appellant, fundamentally they need to be able to show that if they're not allowed immediate review of the trial court's interlocutory order, they will be harmed. And in a scenario where all that happens is they wait a little while, then they go to trial, then they win, I would suggest that they haven't been harmed. They aren't being harmed in that scenario. All they've had to do is they've had to wait a little bit longer because they lost a pretty important initial motion in the trial court, but that happens all the time in our cases. That's not you don't have a substantial right against that. If it was just the delay in getting back to court after a wrongful trial court interlocutory order, I would imagine there'd be a lot more interlocutory orders that needed to be reviewed by this court.
So I have this question about that scenario that you just laid out. Assuming that one of the facts being contested here is whether or not the use that is contemplated, that the permits have, at least the briefing says permits had been sought to build this plant, whether the contaminants will actually reach the creek and contaminate the water, right? And if in the first trial, a trial judge looks at all the expert testimony and says, no, I've concluded there will be no contamination, there's no potential harm here, there's no problem with the rezoning. Is there not the danger that at least there will be some preclusive effect of that fact finding in a second trial over the same issue, whether the same plant in the same location would have the same impact on the water? And so aren't they harmed in their ability to defend their interests if they're not participating in the first case?
Well, thank you for that question, Justice Earls, and I'll answer it sort of in two different parts, if I may. First, just from the standpoint of the claims that have actually been asserted by all the plaintiffs, including the town and also the plaintiffs that are still in the trial court, that claim does not turn on any issues related to the industry that is locating in that rezoned property, or what they do, or what kind of emissions they may emit. The claim that is alive in the trial court is only a claim about whether the county commissioners were essentially, under the Allred versus City of Raleigh case from many years ago, were myopically focused on a particular project and did not consider all permissible uses in that particular zoning district.
So there's still a factual determination that a trial court would make in the course of the litigation. So different fact.
There would
but
be.
Yeah.
I agree. And so the second part of my answer, Justice Earls, would be that as much as the county's lawyer, I would like to be able to say that I could use a good outcome against the trial court plaintiffs against the town if the town ever were to be back in the trial court. I think that it would be very difficult for the county to do that because, of course, the town would say, we were not part of the litigation where that issue was decided or that claim was decided. We were stuck without an interlocutory appeal, awaiting our opportunity to argue standing before the Court of Appeals or the Supreme Court, and therefore, what you did in the trial court is not applicable to us. And I would have a very difficult time arguing against that position.
Right, because that's offensive collateral estoppel, and you really can almost never invoke that. So if they're kicked out of the case, to come back and say, it all got decided without you,
Yeah.
courts usually say, no, that's not how it works.
I would love to find a way in this particular case, but I don't think I'll be able to. So one other thing I would mention about our case law on inconsistent verdicts, and I think this is also important. There is a feature of our case law that I hope won't be overlooked. Creek Point is the one exception to this rule, but otherwise, as best I can tell, all of our jurisprudence on the inconsistent verdicts doctrine requires the appellant, the party seeking to invoke appellate jurisdiction over an appeal of an interlocutory trial court order, has to be able to say, and let me tell you what the three things are, I think, that an appellant seeking to invoke the doctrine has to show. The first thing, and this is what I'm going to come back to in particular, the first thing is, that appellant, the appellant seeking the review, faces the prospect of two different trials. And second, that those two trials, or those two potential trials, will be based on the same set of facts. And third, that those trials might result in two different verdicts, which are so inconsistent with one another that they are irreconcilable. Because as I've already mentioned, there are instances in our case law, and the Green versus Duke Power case of this court is one of those, where the court said, yeah, there could be inconsistent verdicts, but they're not going to be irreconcilable with each other. And for that reason, inconsistency is not the important thing. It's irreconcilably inconsistent that we have to find in order to invoke the doctrine. But let me go back to the first point, and that is the appellant. This is what I think the case law says is the first requirement to invoke the inconsistent verdicts doctrine. The appellant seeking immediate review needs to be able to say, I, the appellant, am facing the prospect of two different trials. That's the first thing you've got to show before you then talk about, and those two trials could be on the same set of facts, and those two trials could result in inconsistent verdicts, and those two inconsistent verdicts could be irreconcilably so. Before you get to any of that, you first have to be able to say, I face the prospect of two different trials. The town of Dobbins Heights cannot say that.
But isn't that because most of these situations are not 6 plaintiffs bringing the identical claim, but one plaintiff bringing 5 claims, and one of the claims gets dismissed? So the court's thinking about that scenario and not the scenario in this case where you just have 6 different plaintiffs, one of the plaintiffs gets dismissed rather than one of the claims of a single plaintiff.
Yes, Justice Dietz, or a situation where you've got a single plaintiff and multiple tortfeasor defendants, some of whom get dismissed, some of whom don't, in which case the plaintiff then faces this choice of, do I go forward against the plaintiffs I've got, knowing I might have to do the same trial later against the defendants that have been dismissed if I'm able to overrule that in the appellate courts. Here's what I'd say about that. Yes, it is true that that's where we see our courts writing on this issue, but I think that's for good reason. I mean, let's think about what is, so the town says, let's say the town doesn't have to say, we face the prospect of two different trials, because we know they can't. Unlike all the appellants in all the cases where the doctrine has been invoked, other than Creek Point, we know that that's the case. But let's say they can get over that hump. They still have to describe how there are two different verdicts that would be irreconcilable with each other and how they will be harmed. But in the scenario they've laid out in their brief, again, page 9, page 11, the one we've talked about, where the current plaintiffs lose, then they get back to the trial court and they actually beat the county, they haven't been harmed.
Well, here's, I think, your friend's argument that he made. The risk of inconsistent verdicts in that scenario is because your client's going to proceed with the rezoning and say, I'm holding a judgment from a court that rejected this declaratory judgment claim and says move forward. And then, your friend's going to say, I'm holding a judgment my client has that says you can't go forward with it. These two judgments don't fit together. That's the inconsistent verdicts. You just say that's a reconcilable difference in your view?
Yeah, I don't think it is irreconcilable in a way that harms the town, because I imagine my friends would say, whatever might have happened before, the last Superior Court judge who has made a decision on this has found that the county's action was invalid. And I think the county would be hard-pressed to ignore that simply because we had gotten some other result in an earlier case. And this can come up in case, remember, the town didn't have to file its claim with these other plaintiffs. They could have filed a separate lawsuit, could have used the same claims, could have just copied the complaint of the other 5 plaintiffs. In that event, I would have, I'm sure, asked the trial judge to use the trial judge's discretion to consolidate under Rule 42, but I wouldn't have a right to do that. So these 2 cases could have proceeded and gone to judgment separately. We might be in the same situation.
I'd like to draw your attention back to really an earlier part that's been argued. Your friend basically has said they've done the best they could to explain these inconsistent verdicts at the pleading stage. What do you make of that? I mean, whatever they would say would be speculative, or at least that's their argument. How should we factor that into our decision before we even get to what you're talking about now?
Well, I think that we agree with the Court of Appeals. We agree that there wasn't enough there. There was something. I mean, it wasn't a Doe situation where there was literally no analysis given on this issue. However, we just don't think they explained, they didn't speculate enough. In their brief, they say, essentially, the Court of Appeals would have required us to engage in needless speculation about the potential inconsistent verdicts that might arise. We disagree with that position because we don't think that the appellant, who has the burden of showing that the appellate courts have jurisdiction over an immediate appeal, we don't think that placing that burden on the appellant is ever unduly burdensome. However, we do agree to some extent in that the Court of Appeals is saying it does require speculation, and we think it was their burden to speculate because the appellate court has to understand, okay, what is your theory about how there could be 2 trials, 2 verdicts, and really most importantly, how they could be irreconcilably inconsistent with one another. And that's the analysis that was not presented to the Court of Appeals in the briefs. And frankly, it's not even analysis that has been presented here, because although they do roll out a hypothetical in their brief and here, of course, that would result in inconsistent verdicts, they can explain how those 2 would be irreconcilable with each other to the detriment of the town of Dobbins Heights. Because essentially, they would be waiting to win the case. That's what they're saying. We should not be forced to wait to win our case. But I don't think waiting to win your case is, it violates a substantial right, such that there should be an immediate appeal of an interlocutory trial court order.
So Creek Point cites this court's decision in Burnick v. Jordan. Can you explain to me why Burnick, in your view, is not controlling?
Well, Justice Allen, I don't think, so Burnick, I do not believe, unless I'm mistaken, got into the issue of what exactly needed to be said in the statement for appellate review or the grounds for appellate review. Burnick is binding case law. It's not exactly on point here because, of course, in Burnick, you had a single plaintiff and multiple tortfeasor defendants, and the analysis was the stereotypical inconsistent verdicts analysis where a defendant was dismissed, the mouthpiece manufacturer, and the plaintiff was forced with the prospect of having to go to trial against one set of defendants, essentially the other hockey player who hit the plaintiff in the mouth and his team, while waiting to go forward with another trial against the mouthpiece manufacturer if the trial court's summary judgment in favor of the mouthpiece manufacturer was ever overturned. And this court, in that case, said there is a risk of irreconcilably inconsistent verdicts in that, in the first case, the jury could decide, you know, getting hit in the mouth by another player in a hockey game is just sort of part of it, and, you know, it probably wasn't intentional. It's really the mouthpiece manufacturer who should have built a mouthpiece that would have protected the plaintiff against that sort of typical harm. And so judgment in favor of those defendants. And then later, when the mouthpiece manufacturer made it back to the trial court, there'd be a trial, and the mouthpiece manufacturer would say, we think that was an intentional act on the part of the other hockey player, and we can't be held responsible for intentional acts through the manufacturer of our mouthpiece. And a jury in that case could decide, yeah, it probably was an intentional act. We're not going to hold the mouthpiece manufacturer liable for that. And the court said those two inconsistent verdicts are irreconcilable with each other in the sense that if the same jury heard the cases against both sets of defendants, they wouldn't have decided that. They would have picked one. Somebody was responsible, most likely, and the plaintiff, therefore, would have gotten his day in court and been able to try the case against all the defendants in a single case. But that's not, obviously not the factual situation we're faced with here. So, as to Creek Point, we would acknowledge that Creek Point is a similar procedural setting. That's why they cited it. We understand that. But Creek Point was a 2-to-1 decision of the Court of Appeals from back in 2001, which was entirely focused on this other issue of associational standing for homeowners associations. It's not even clear to us that it was a contested issue in front of the Court of Appeals, and that's probably why there was no analysis other than citing cases like Burnick of this court, which are factually inopposite. So we think this court can ignore Creek Point, and we don't think you're bound by it, and we think you can take this opportunity to make clear that it's not good law. So for those reasons, we don't think the town has established appellate jurisdiction here. We do not think the inconsistent verdict doctrine applies. Just very briefly, I will make a couple points about the standing issue. Chief Justice Newby, I heard you and what you said about the contents of the petition, and we do not disagree with the idea that this was not part of the petition that was granted by this court. So I will only very briefly say that should the court decide to take this issue up in sort of its broad supervisory authority, we believe that the trial court was entirely correct in dismissing Dobbins Heights, and Dobbins Heights only, from the case below, because Dobbins Heights is simply too far away from the rezoned property to have the sort of specific personal and legal interests that this court has required in the Taylor versus City of Raleigh case. That means that they would be directly and adversely affected thereby. We agree.
I'm sorry, just on this point, and I understand your argument to be in your brief that because this case has been pending so long, that it's, you know, there's sort of administration of justice reasons for us to reach this, and now it's been briefed. And so my question for you is, how is there daylight between the if the concern is the contamination that impacts a water supply, if both Hamlet and Dobbins Heights are getting their water from the same place, how is there any difference between the standing that Hamlet has? I mean, I understand location, but in terms of impact, they're both getting their water from the same place. What's the distinction between Hamlet and Dobbins Heights?
I would have to speculate as to why the trial court made the decision in the way the trial court did, because we did move to dismiss Hamlet as well.
But you are arguing to us that Dobbins Heights doesn't have standing.
Right, right. And so to speculate as to why Hamlet was allowed to stay in the case and Dobbins Heights was kicked out of the case, I can only say that Hamlet does own a very large piece of property You can see this in our brief. The city of Hamlet owns a large piece of property outside of its city limits that is much, much closer. I think at its closest point is maybe a half-mile away from the rezoned property. And so in that sense, as a landowner, Hamlet is somewhat akin to the two neighbors who are adjacent to the rezoned property. You are correct, Justice Earls, that if it's all about the water, then it would be hard to substantiate why there would be different treatment of Hamlet versus Dobbins Heights, because they're all drinking the same water. So I have to conclude that the trial court thought that Hamlet, as a landowner, as a owner of a piece of property very close to the rezoned property, had standing for that reason, instead of because of this sort of water contamination issue that the town of Dobbins Heights is forced to raise because they do not own land near the rezoned property.
Thank you.
So I'll just wrap up by saying,
Does the town of Dobbins Heights have a personal and legal interest in clean water?
I think that generally speaking, they probably do, as do we all. I think the question is there enough of a connection between the rezoning, the legislative action of rezoning a piece of property by the county on the one hand, and the clean water, the generalized interest in clean water on the other hand. In the Morgan versus Nash County case, the Court of Appeals looked at the same kind of argument and decided that the connection between the city of Wilson's challenge to Nash County's rezoning to allow for a chicken processing facility was simply too attenuated. I think they used the term conjectural and hypothetical. This case is a lot like the Morgan versus Nash County case, which found that the city of Wilson did not have adequate standing to pursue that claim, simply because, even though the city of Wilson could say the process water from that chicken plant will end up being used in a spray field, which is within a watershed that we draw our water supply from. They made the same argument, and the Court of Appeals, I think very rightly, rejected that argument. And even though in that case the Court of Appeals did cite some federal cases based on sort of Article III injury in fact, constitutional injury in fact limitations on federal courts' ability to hear cases, I do not think the Morgan case was implying that that is a constitutional requirement, and of course the court has made clear that in our North Carolina Constitution there is no injury in fact requirement. But our case law around standing, especially as it relates to challenging zoning decisions, is clear that you've got to show you have standing, and that's the Taylor case and all the progeny that flows therefrom.
I realize your time is waning, but the air quality and it being at the pleading stage where this dismissal occurred before discovery, how do you deal with the fact that that at least could be argued, or it appears perhaps premature?
I would just say, Justice Behringer, that I'd answer that question by saying the legal claims asserted in the rezoning do not depend on any testimony about what any given industry may end up doing out there. Now, it's true that there is an industry that has built a plant out there now and is operating. But the legal questions that are before the trial court, and will continue to be before the trial court, are simply whether the county commissioners failed to take into account the whole range of uses that is allowed in the local ordinance in that zoning district. That is the claim they have asserted, and that depends on evidence only relating to what the commissioners were thinking about or were not thinking about at the time they approved the rezoning. So the stuff about the air and water pollution really is not relevant to the claims that have been brought by these plaintiffs, including the town of Dobbins Heights. So my time is about to expire. We appreciate your time. We don't think that appellate jurisdiction has been supported here because we don't think the inconsistent verdicts doctrine applies to this case, and we'd appreciate this court affirming the decision of the Court of Appeals below.
Thank you, counsel. Rebuttal.
Yes, thank you. Let me just continue where I left off and break down a little bit of the Taylor v. City of Raleigh standard. And we do contend that that has always been the law, at least to our understanding of what it is to go and have standing to challenge legislative decisions. Now, I think committee-to-elect Dan Forrest is actually controlling, because it's quite clear that that analysis was supposed to apply to standing under North Carolina Constitution. But in any event, since Taylor, there has been no bright line test developed by the courts on what it means to be specific personal or legal interests. But what the courts have essentially looked at is like the degree of harm. And I also want to go and mention that although the courts do take into account, the proximity to the rezoned property, that fact alone is not dispositive on whether you not have standing. The key is whether you will be directly and adversely affected by the rezoning, looking at the degree of harm that will be suffered by the plaintiff. And here, again, Dobbins Heights has met that standard. If the rezoning is upheld, a biochar production facility will be built on that property. And for all the reasons that I went through before about the toxins, emissions, and pollutants coming from that facility, affecting the air quality and as well as the ground and surface waters, we have also met the Taylor standard. To the extent that Taylor applies as opposed to the Dan Forrest test. I will also like to go and address the Morgan v. Nash County case. My colleague has left out a couple key facts in the ultimate holding of why the court held what they did. So in Morgan v. Nash County, the city of Wilson and a couple property owners challenged a rezoning for a poultry processing facility. Now, as a part of the poultry processing facility, there is also spray fields that were going to be used from the facility to disperse wastewater. But those spray fields were located several miles away. And near those spray fields is a watershed area where the city of Wilson obtained its water. And so the city alleged, well, the spray fields are going to go and pollute our water supply. But what the court said here is the city, you don't have standing because there's no direct and adverse effect from the rezoning, because really two main reasons. The first, the spraying of wastewater on that second tract of land was already a permitted use on that property. So it didn't matter whether the rezoned property happened or not with the poultry facility. And it also said, number two, it emphasized the fact that the spray field property was located several miles away from the rezoned property. Thus, the city of Wilson was too remote. They were about 3 miles away. And here, Dobbins Heights is 2,500 feet from the proposed biochar production facility. And the biochar production facility is not a permitted use without this rezoning.
I want to get you back, because you're almost out of time, to the
Sure.
issue for which we allowed the discretionary review here.
Absolutely, Your
So
Honor.
your friend, I'm going to paraphrase the argument a little bit, but your friend says, this is why there's no right to an immediate appeal. Yes, in theory, there could be inconsistent verdicts in the sense that you may have two judgments you're holding up. One says one thing, one says the other. And that might be a problem for us, but we're not particularly concerned about that. But as to your client, there's no harm, because you're going to get your day in court if you're right on standing eventually. And you didn't have to be part of the rest of the plaintiffs all combined together in one suit anyway. All 6 of these plaintiffs could have brought 6 separate lawsuits. And then there could have been 5 who won and 1 who lost, or any combination. That's just how it works in litigation. So that's why this isn't sort of the classic inconsistent verdict case. So respond to that argument.
Well, I think the heart of the answer to your question here, Your Honor, is you're right. They could have been separate claims, right? But we all followed the same action. That's the common interest. But again, I want to go back to the hardship if you're out of the case at the pleading stage. No right to go and appeal. You have no right to go and pursue discovery or stipulate to facts or settle the case. So in this case, I think opposing counsel said you're just waiting to win your case is the only right that is lost. Well, what happens if Hamlet and the other 4 property owners decide to settle the case? Dobbins Heights has 0 stay. So you have to go and wait 2.5 years to go and figure out you have standing and the case is settled. That's the effect of the substantial right. It's the harm. I mean, that's, I think, the overall theme here, not getting into the weeds of the inconsistent verdicts. And that's where I disagree with my colleague here that, you know, especially with the Creek Point case, you know, with the effect of the substantial right, I think, again, the substantial right and why they were just very self-evident of, you know, this is a substantial right is because of that harm if you're dismissed. A plaintiff is just dismissed from the lawsuit and has to go and wait an extended amount of time to be able to go and get heard on that issue, and then it can, again, for all the reasons we discussed, can go and come back. If there are no further questions for the court, in conclusion, we respectfully request that the court reverse the Court of Appeals decision to dismiss Davensight's appeal and remand it back to the Court of Appeals to address the issue of the town's standing, or in the alternative, find that the town has standing by using your discretion to go ahead and review that issue here. Thank you very much.
Counsel?
All rise.